my learned friend will point to those passages where those words may be found. We submit that they may not. There are two paragraphs that are crucial to the consent debate. And your Lordship will find that at page 81 of the record, paragraph 78.8, and then over the page, 82, at paragraph 78.9. Out of an affidavit of 35 pages long, two short sentences on consent, or so-called consent. What do they say? In paragraph 78.8, it says, at the time when the applicant was handed over to the DHA by the South African High Commission, she did not, be it verbally or otherwise, offer any resistance or protest. A paragraph over the page, 82 of the pleadings bundle, the applicant informed all and sundry that she wanted to return to South Africa to her children. That's all, my lord, on the question of consent. I accept there's another paragraph about, made in passing, about being informed of a lawyer. Those are perhaps the three paragraphs upon which consent was founded. Now I take this court to a judgment of the Supreme Court of Appeal. And this is the most recent case on consent and waiver. It's a judgment of the SCA handed down, I believe it was in March of this year, 13 March of this year, at page 27 of the Leave to Appeal Authorities bundle. And it starts at paragraph 19. Now, if I may take a step back, my lord, in our submission, the Spagni case represents consent a la Muhammad. Informed, clear, and in this case, in writing. No ambiguity as to what the person was consenting to, who they were offering consent to, the circumstances of the consent. And it's important that I take the court to three international law principles that inform consent. And they're all covered in this judgment. So paragraph 19, this is what the SCA says in its latest case on waiver and consent. As regards the argument that the extradition request continues to have legal implications for Mr. Spagni's ongoing trial, it is essential for proper consideration of the argument to quote the contents of Mr. Spagni's affidavit filed in support of his waiver of rights pertaining to extradition. They are as follows. Affidavit in support of waiver of rights. I, Spagni, having been fully informed by my attorneys, etc., and the names, of my rights under the extradition treaty in force between the United States and South Africa under 18 USC Code, and then it gives the code, do hereby waive any and all such rights and ask the court to expedite my return in custody to South Africa. So there's a clear, unequivocal waiver. Do hereby, not I want to return to my children with respect, do hereby waive any and all such rights and ask that the court expedite my return in custody to South Africa. My attorneys, with whose advice I'm satisfied, have explained to me the terms of the extradition treaty in force between the United States and South Africa. So there's mention of an extradition treaty. Of course, we know that there was no mention of an extradition treaty, the SADC protocol on extradition in this case. So we have mention of the extradition treaty applicable and Title 18 of the United States Code, and the complaint filed by the United States Attorney in fulfillment of the United States Code, and the complaint filed by the United States Attorney in fulfillment of the United States treaty obligations of the Government of South Africa, treaty obligations of the Government of South Africa. I understand that pursuant to 18 USC, I'm entitled, and this is important, my Lord, to a hearing at which the following facts would have to be established. We make a note, prima facie case, and this is a fundamental principle of international law. In every extradition proceeding, the state must prove that there's a prima facie case for an individual to be returned, a sought person to be returned. And what does that include? That currently there's an extradition treaty in force between the United States and South Africa, that the treaty covers the offences for which the extradition was requested. We ask that the Lordship make a note there, that's the double criminality principle under international law. that I'm the person whose extradition is sought by South Africa, and that probable cause exists to believe that I committed the offences for which extradition was requested. I admit that I am an individual against whom charges are pending in South Africa and for whom the process is outstanding debt. I fully understand that in the absence of any waiver of my rights, I cannot, and we stress this, my Lord, I cannot be compelled to return to South Africa. That's the international law position of the SCA of this year. I cannot be compelled to return to South Africa unless and until a court in the United States issues a ruling certifying my extraditability and the Secretary of State of the United States issues a warrant of surrender. I've reviewed the complaint and I fully understand my right to a hearing at which my counsel and I could challenge the extradition request presented by the government of South Africa. Crucial words, I hereby waive my rights under the extradition treaty and the application of sections 918 of the US Code and agree to be transported in custody as soon as possible to South Africa. I agree that the conditions of my bail will continue, and it goes on and on and on, and no representative, official or officer of the United States or government of South Africa nor any other person whosoever has made any promise or offered me any form of inducement or made any threat, and then it goes on to say effectively that it wasn't made under duress. So we submit, my Lord, that in determining whether there are reasonable prospects of success, the SCA will reach a different conclusion on the question of consent. In determining whether the Mohammed requirements for onus were satisfied, the court will look at what the SCA has said about consent in Spagley, the form that consent takes today under international law, and your Lordship will compare this to the affidavit of the SAPS, where you will find not a word mentioned on consent, where you'll find not a word mentioned on waiver or agreement, but instead two passing remarks: I'd like to return to my children. Offer no resistance. Is that informed consent? Was she informed of the treaty between South Africa and Tanzania, SADC Protocol on Extradition? Now, we know, of course, that Mohala's case says that you don't have to be informed of the treaty, but we would respectfully submit that that's been overridden by the SCA's judgment in Spagley. And if it hasn't, that is a compelling reason in and of itself for leave to be granted. But what was she consenting to? Was Dr. Magudumana consenting to a disguised extradition? To whom was the consent made? We're not told. When was the consent made? Was it after Home Affairs exercised the unlawful power under Section 41 of the Immigration Act to arrest her using a South African piece of legislation in a foreign country? We of course know from the principal arguments that provision is of no assistance to Home Affairs, and we also know that the reliance on the Vienna Convention on Diplomatic Relations is of no assistance. We've made those arguments already. So when was consent made? To whom was it made? Under what circumstances was it made? Is it clear? Is it unequivocal? Is it in writing? None of those facts appear in the answering affidavit, and we would respectfully submit that the onus is not discharged. Might I make a further point, my Lord? And it's this. It's important to take note of where the argument and consent comes from. It's made with a great deal of vigor, with respect, by the SAPS. But it's important to look at the SAPS's role in this litigation, to see how this consent notion plays out. Now remember, this application was launched and Home Affairs said, no, you've made a crucial mistake. This was our operation. This wasn't the SAPS's operation. We were the main players here. SAPS played a peripheral role. We chartered the plane, our officials went there. This was not the operation of SAPS. Home Affairs say, I exercised arrest powers relying on a South African statute in Tanzania. I believe that I could do so under the Vienna Convention on Diplomatic Relations, the inviolability principle. As I've said, we've demonstrated that to be patently incorrect as a matter of both domestic law and international law. Is it appropriate for SAPS, who say, I am not involved. All I was doing there was offering protection to the officials of Home Affairs to take the consent argument. My Lord, with respect, that in and of itself is dispositive of the unequivocal consent position. Because if you have two conflicting views by respondents, how can there ever, with respect, be unequivocal consent? If one party says, I exercised an arrest power in a foreign country, and another party says, no, there was consent, the respondents themselves are confused as to what the correct route was. And we submit under those circumstances there can never be clear and unequivocal consent. I don't want to belabor the point, my Lord, but it might be useful for me to give the court certain references. So, for example, at paragraph 54, page 74 of the record, paragraph 69, page 78, and paragraph 75 at page 79. Can I just use one of those references to clarify the role of the SAPS in this litigation and in the unlawful disguised extradition of Dr. Magudumana? This is what they say at paragraph 75. Following their handover to the DHA, the applicant and Bester were transported back to South Africa in the DHA plane. The plane left Tanzania at 23 minutes past 12 midnight. Throughout the whole process, SAPS's version, my Lord, throughout this whole process, the SAPS only provided protection and security services to DHA officials on the plane. So we would submit, my Lord, that it is puzzling with respect that SAPS, who says, I didn't play a prominent role, now says there was consent, it was informed, the requirements of Mohammed are met. Who was the consent made to? It certainly wasn't made to Home Affairs. Was it made to SAPS? If so, which official of SAPS? And if that's the case, how does that square with SAPS's role that it played a hands-off role? SAPS, with respect, must choose a lane and stick in it. They can't have it both ways. They can't have consent, and also we didn't play any role at all. And then finally, my Lord, you've heard arguments about, in the heads of argument at least, on December and Mahala's case. Could I just distinguish December and Mahala's case from this case? The crucial distinction we respectfully submit between December and Mahala is that in December and Mahala there was a finding of there was no finding of unlawfulness. So your Lordship, in December's case, what was said was the accused at that stage was merely a suspect. Well, he wasn't even a suspect. He agreed to travel from the Ciskei to South Africa with the SAPS in order to assist the SAPS in the investigation. And the AD said that there was no unlawfulness on the part of the SAPS. At page 86 of the bundle, and it's page 440 of the case, between letters D and F, Ninaba JA says, there was no evidence of any sort, and the appellant willingly consented to return. There was no violence of any sort, and the appellant willingly consented to return with them to East London, that's the SAPS, in order to assist them in their further investigation. So when December returned to South Africa, he returned to South Africa not as an accused person, only for the purpose of assisting the SAPS in their investigation. And then in Mahala's case, my Lord, at page 99 of the authorities bundle, page 516 of the case, between letters C and E, the following is said by Uber JA. In the present matter, the proven and accepted facts established that the South African police, and these are the important words, did not unlawfully abduct the accused from the Ciskei and the Ciskei territory. So the distinction to be made between December and Mahala's case is that here, in paragraph 38, as read with paragraph 25 and 28, this court makes a finding of unlawfulness by the respondents. In December, there was no such finding. Consent was permissible there because there was no unlawfulness. And we submit that that can't be the case where there is a finding of unlawfulness, as in your Lordship's judgment. So on that score, December and Mahala are distinguishable. May I make a few arguments regarding compelling reasons. The first concerns Shaba's case, my lord. Now, Shaba's case wasn't dealt with in the written submissions for the SAPS, but it was dealt with by Macmillan Friend for Home Affairs. And we submit that Shaba is a case that is in conflict with this court's judgment. Because in Shaba, the court there concluded that you cannot consent to an unconstitutionality. And your lordship will find this at page 46 of the authorities bundle. And it's after the letter H. And my Afrikaans isn't very good, my lord, so you'll have to bear with me. It says, verder is ek van oordeel dat klassenregte verkeer deur die privaat-regtelike regsverkeer van afstanddoening van regte hier te gebruik. In other words, Justice Clarkson got it wrong to use private law concepts of waiver in a case that's similar to these facts, Matabula's case. Die bepalings van hoofstuk 3 van die grondwet skep onvreembare regte. The provisions of chapter 3 of the interim constitution give you inalienable rights. And these are the crucial words. May renounce them. Now, the importance of Shaba's case is that it was actually cited by the Constitutional Court in Muhammad. And what the court does there at footnote 55 of Muhammad's case is reference Shaba in the ongoing debate about whether you can consent to an illegality, and it effectively, and your lordship will see this at page 73 of the record, and the Concord says this, in Shaba and another, the court held that the doctrine of waiver is not applicable to inalienable fundamental rights. That's how the Concord interpreted Shaba's case. An individual may choose not to exercise a constitutionally protected right, but he's always free to change his mind. Now, in the submissions for Home Affairs, this argument is made. They say Dr. Magudumana didn't choose to exercise her right to freedom and security of the person. So it's a changed argument. So it's not a waiver argument, not a consent argument, but she chose not to exercise the right. With respect, that reveals a fundamental lack of understanding of the nature of rights. There are certain rights that require a positive act. So, for example, your right to free speech. If I say nothing, I'm not waiving a right, I'm not exercising my right to free speech. I'm always entitled to it, but I just don't use it. The same is true for the right to vote or the right to access to court. If I have a dispute, I may go to court, or I may not. I may just choose not to have my dispute heard. But there are other rights that don't exist in the same way, so they don't require a positive act. Your right to dignity, for example. In order to exercise your dignity, you don't have to do something positively. It exists. You're always entitled to it. The state can never breach it. And the same is true for freedom and security of the person. South Africa can't exercise a right to arrest you in a foreign state because, well, firstly, the law doesn't permit it, but secondly, you're entitled to that right. You don't waive that right. You can't choose not to exercise it. It exists as an objective fact, in the same way that the right to dignity exists as an objective fact, regardless of how you act. So that reveals, in our respectful submission, a lack of understanding of the nature of rights. Some rights require positive acts. Other rights exist in and of themselves. They don't require any intervention from anyone. And if the state acts unlawfully, that's a violation of your right. Distinction that Home Affairs tries to make in respect of Shaba's case. Now, this court is of course aware that Noble properly says that the most compelling reason to grant leave to appeal is that there are conflicting judgments. And we respectfully submit that Shaba in this case is such a case. There are two cases of the same level, both High Court decisions, and it's in the interest of justice that the SCA clarifies the question once and for all. I'm going to say a few words about why it's important that the question of consent be dealt with as a matter of constitutional law shortly, but Noble Properties and Shaba, in our respectful views, on all fours. The final point in relation to a compelling reason is, can you consent to an illegality? And this is an important question we respectfully submit, my lord. Because in Muhammad, the court left the question open. It appears from the written submissions of SAPS that they don't think so. It's a bit difficult to understand, but they don't think so. It's quite clear in our respectful view from Mohammed that the question was left open. This is what the Constitutional Court had to say. It is open to doubt whether a person in Mohammed's position can validly consent to being removed to a country in order to face a criminal charge where his life is in jeopardy. Now, the distinction our learned friend tries to make is, well, that only applies to death penalty cases. That reading of Mohammed, in our view, is untenable. Of course, it applies to all forms of illegality. And if you look at the footnotes, 255, at the end of that sentence, you'll see, for example, Shaba, you can't consent to an illegality. So that reading, in our respectful view, isn't a good reading of Mohammed's case. But then the court goes on. We did not have the benefit of full argument in this, and it would accordingly be unwise to express a view on it. We will, without deciding, and those are the crucial words, be in favour of the respondents that the proper consent of such nature would be enforceable against Mohammed. In other words, what the Constitutional Court is saying is this: look, we haven't had the benefit of submissions on whether you can consent to an illegality. That issue just isn't addressed. But assume that you could. This is why you're still wrong, is what the Concord tells the state, because you haven't proved consent. And what I find particularly, what we submit as particularly interesting, is if your Lordship looks at the footnotes to paragraph 56, the court says, to be enforceable, however, it would have to, and it talks about the requirements for consent. To be enforceable, however, it would have to be fully informed consent, and one clearly showing that the particular applicant was aware of the exact nature and extent of the rights being waived in consequence of such waiver. And it's like a series of cases, all cases, some in the extradition context, dealing with waiver and consent under international law in a similar way to Spagni. And what's remarkable here, my Lord, is you don't find December and Mahala. If December and Mahala are good propositions, for example, on consent, one would have thought that the Concord would have cited it, but it didn't. It instead looked to the authorities of other jurisdiction on consent and waiver. We submit that you can never consent to an illegality. And that's because all constitutional inquiries are not subjective in nature. And consent, in our view, is inherently subjective. It requires the person giving it to say, I'm okay with unconstitutional conduct. That, in our view, is inconsistent with Section 2 of the Constitution. All law and all conduct is measured against one thing and one thing only, and that is the Constitution. As the court held in Ferreira, the subjective positions of the parties are irrelevant. What Dr. Magudumana might have thought, what anyone else, the objective question is, does the Constitution say this is permissible or impermissible? There's no provision for waiver in our Constitution. The Concord is higher than the Constitution. And we find this not only in Muhammad, but also in Andrew's case, a judgment of Justice O'Regan. Your Lordship, 2 of the authorities bundle, and it starts at paragraph 216. This is the majority judgment of Justice O'Regan. In that case, O'Regan, ADCJ. And she says this: if we understand Section 34 not to be directly applicable to private arbitration, the effect of a person choosing private arbitration for the resolution of a dispute is not that they have waived their right under Section 34. They have instead chosen not to exercise their right under Section 34. It's the distinction I made earlier, my Lord. I do not think, therefore, that the language of waiver used by both the European Court of Human Rights in Suvanimi and by the Supreme Court of Appeal in Telecordia is apt. Indeed, and this is important, we respectfully submit, indeed, it may not be apt in relation to constitutional rights at all, but this is a topic for another day. And then there are 2 footnotes which we submit are important. So if you look at footnote 28, my Lord, it says, 29, pardon me, down the page, for the discussion of the difference between waiver and the choice not to exercise a constitutional right, see Muhammad, and the cases cited in Muhammad at footnote 55, which includes Shaba's case, some constitutional rights inhere in the individual and do not fall to be exercised and may arguably therefore never be waived. See that, my Lord? May therefore never be waived. See Muhammad. by C. Muhammad, C. Shaba as well, because of footnote 55. The question is a difficult one and therefore need not be further elaborated here. And then at footnote 30, there's a citation to Professor Woolman's argument on why you can never waive constitutional rights. I'm not going to go through it in detail. It's an argument which we respectfully submit is for the SCA. All we need to do here is demonstrate that it's an important question of law that the SCA ought to deal with. But your Lordship will find the argument of Professor Woolman in particular at page 108 of the authorities bundle. He goes through all the cases, Muhammad, Telecordia, foreign authorities, and he concludes with this. Here then is the strong, coherent line that courts should adopt. No fundamental right can ever be waived. Consent to a given state of affairs, contractual waiver, can only occur where no right has been violated. The basis for this conclusion is not as casuistic as it may appear. Some rights in Chapter 2 will rarely, if ever, permit an interpretation of their scope that will create a space for legal and social, and it goes on. But the point there is this is an argument by Professor Woolman, considering Muhammad and all those other cases, as to why you cannot consent to an illegality. So, my Lord, because of the doctrine of objective constitutional invalidity, the Constitution and the Constitution alone scrutinizes the conduct of an individual. You cannot escape it. Unconstitutional conduct isn't transformed by a person saying, I agree to it, for example. We would think it would be odd, for example, my Lord, if an individual who is tortured by the state said, I was tortured by the state, but I agree to it. That, in our respectful view, wouldn't be consistent with the supremacy clause of the Constitution. And because the question has been left open, Muhammad, Andrew's case, the authorities we've given you from Professor Woolman that tracks through it, we submit that this is an important question of law for the SCA to deal with. May I make just a few short points in response to the written submissions which we've received yesterday? The first argument is that this court wasn't required to make an order under 172(1)(a) of the Constitution that the conduct of the respondents was unlawful because this relief wasn't sought in the notice of motion. The argument is that even though the court concluded there's an illegality, because it wasn't sought in the notice of motion, this court doesn't have to make that order. Now, with respect, my Lord, we've given the court the authority in Morderklip. We've given our learned friends the authority in Morderklip. Not once did they deal with it, either in the primary proceedings or in written argument today, because Morderklip provides this court with a complete answer to that question. This is what the SCA said in Morderklip. If a constitutional breach is established, this court is, and this is, if your Lordship wants the citation, it's Modder is Squatters and Another versus Morderklip Boerdery, 2004, 3, all SA, page 169, SCA, at paragraph 18.
Just repeat that.
Sorry, my Lord.
2004, 3.
2004, 3, all SA, page 169, SCA, at paragraph 18. This is what the SCA says in Morderklip. If a constitutional breach is established, this court is, as was the court below, mandated to grant appropriate relief. A claimant in such circumstances should not necessarily be bound by the formulation of the relief originally sought or the manner in which it was presented or argued. That much is apparent in the course of the litigation that took place in Carmichael, Banatiane, and why the further amici in another case were admitted to proceedings. Crucial point there, my Lord, is if an unconstitutionality is established on the pleadings, we respectfully submit that this court must grant the relief that declares that conduct to be unconstitutional. And we know this, of course, from EFF1, the judgment of the Constitutional Court in Nkandla, where the Constitutional Court, and if your Lordship wants the citation, it is in our written submission, but the citation is 2016, volume 3, SA, page 580, Constitutional Court, paragraph 103. That's what the court said in EFF1. Declaring law or conduct inconsistent with the Constitution and invalid is plainly an obligatory power, vested in this court as borne out by the word must. That's the language of 1721A, must declare. Unlike the discretionary power to make a declaratory order in terms of Section 38 of the Constitution, this court, these are the important words, has no choice but to declare, but to make a declaratory order where Section 1721A applies. Why does Section 1721A apply? Because your Lordship considered the pleadings of the respondents as it was required to do in Clascon Evans. And your Lordship concluded that on their version, unlawfulness was established. On their version. We see this at the court's judgment 25, 28, and 38. And once it is apparent from the respondents' pleadings that there is an unlawfulness, the court, in our respectful view, is required to declare it as such, regardless of whether the applicant sought it in its notice of motion. Of course, how could the applicant know? The applicant couldn't. The applicant can't preempt certain facts. Those facts appear from the respondent. It might be helpful to consider Grainor Passy on this score, judgment of the SCA, where the same point is made before. This is what I believe it was Justice Wallace had to say. Furthermore, Grainor Passy is a case, the citation of the case is 2019 to All SA 307 SCA, paragraph 38. This is what Justice Wallace says. Furthermore, where a matter is within the exclusive knowledge of one of the litigants, less evidence will be required from the other party to discharge an onus. That is particularly the case where the party possessed of the relevant knowledge does not produce it. And if the evidence provided by the party to whom the burden lies calls for an answer, as was undoubtedly the case here, the failure to produce countervailing evidence strengthens the case of the party bearing the onus. In short, my lord, if the respondents put up a version and the court says, hold on a second, on this version you committed an unlawfulness, your own version. In our respectful view, the court is mandated under 172(1)A of the Constitution to grant the order declaring the conduct unconstitutional, regardless of whether the applicant sought it or not. What cases do the respondents rely on? Two cases. The first is De Beers' case. Now, what happened in De Beers' case was, in the High Court, Mr. De Beer brought a challenge, it was during the state of disaster, to one set of COVID regulations made by the COGTA Minister under Section 27(2) of the DMA, Disaster Management Act. So the court is seized with a challenge on the regulations to level 4 of the lockdown. By the time the court hears it, we're on level 3. So what does the High Court do? The High Court declares level 4 and level 3 regulations unconstitutional. Didn't give the minister an opportunity to be heard on the level 3 regulations. What does the SCA say about this? You can't do that. Of course you can't do that. Because the minister didn't have an opportunity to address the challenge on the level 3 regulations. That's entirely different, my lord, to a situation where you get an affidavit from the respondents and you go, on this version, your conduct in this case is unlawful. And of course, the other problem with the De Beer case is that the High Court didn't apply the rationality test correctly. It didn't scrutinize substantive or procedural rationality, but it made a finding of unlawfulness. And it declared the entire set of regulations unconstitutional without the court applying their mind to the individual regulations. And we know from constitutional litigation that you can't do that. You have to look at whether an individual regulation is constitutional or not. A very different situation to this. So with respect, De Beer just isn't applicable to this case. It doesn't assist my learned friends. The correct case is monitored. But there's a second case that they rely on, and that's the case of Garbus. And Garbus was a challenge to Section 11 of the Regulation of Gatherings Act. And it was in the judgment, I think, of Justice Jafta where he says, look, if you're going to challenge something properly, you have to challenge not only Section 11(1) of the Regulation of Gatherings Act, but also Section 11(2). Why is that case applicable? We're not dealing with a challenge to a statute. Again, entirely unhelpful to our learned friends. So we respectfully submit, my Lord, that the argument that this court wasn't required to establish, to grant the 1721A order is inapplicable and inappropriate. It's inappropriate because it's not consistent with the judgment in Modiclip, with respect, and it's not consistent with the judgment in EFF1, where the Constitutional Court couldn't be clearer. Once there's an illegality, the court has no discretion. The Constitution requires that the court declare the conduct unconstitutional. So in summary, my Lord, the opposition is based on three fronts. The first is the Muhammad line being consistent with December and Mahala. I've demonstrated why that's incorrect, with respect. And I've also demonstrated why, with reference to Spagni, the Muhammad onus just doesn't stand. And then secondly, my Lord, in relation to the 1721A order, demonstrated that Modiclip applies and that the judgment of the Constitutional Court in EFF1 is applicable. And then finally, with reference to Shaba, I've demonstrated that the DHA's opposition to the conflicting judgments is inappropriate. We submit that there are both reasonable prospects of success and compelling reasons. If the court finds that I'm incorrect on the reasonable prospects of success argument, in other words, that the Muhammad test was established, then in any event we submit that this court should grant leave, because the question of whether you can consent to an illegality cuts through to both reasonable prospects and compelling reason. So if we're right that you can't consent to an illegality, as suggested by Justice O'Regan in the Andrews case, then we come home on the relief with respect in the SCA, and we would be entitled to leave because it cuts through both ways, reasonable prospects and compelling reasons. Could I just check if I've missed anything? Oh yes. And then on costs, my Lord. I'm not going to say much about it. Your Lordship has our submissions.
Yes, I saw what we submitted in the heads of argument, and I take that.
As it pleases the court. Those are submissions for the applicant.
Argument that there is no reasonable prospects of success of an appeal, there are no compelling reasons. So I would just like to start with our introduction, because my Lord's answer to the matter lies here. I'm being handed over to the officials of the DHA, and a coalition got onto that plane. She came home to South Africa. Why? She said why. She wanted to come back to Italy. That's where we started the previous time. That's where we start now. What does the applicant say? Where did she want to go? She doesn't. She didn't grapple with this. She didn't deal with this at all. My Lord will remember there was a blanket denial. The applicant could not, out of own volition, say, I want to go home, I've been caught in another country, I've been incarcerated. I can't, out of own volition, when South African authorities come to Tanzania to come and discuss and negotiate this matter, I can't, out of own volition, get on that plane and go home with it. That's what the argument is. In law, it's flawed. It's fundamentally flawed. But there are other reasons why the argument's also fundamentally flawed. So let us start with the conflicting judgment argument. You've been referred to Spagni. That is now the SCA judgment of March of this year. My Lord, a passage was read to you. You find that in paragraph 19 of that judgment, And then the startling submission is made that this is what the SEA says. What was read to you, my Lord, was the quotation by the SEA of what was stated in the affidavit in support of waiver of rights. They were quoting from the person's affidavit. It's not the SEA distilling the law, saying what the guiding principles are. And why do they do so? We have to go back. We're back to where we were when we argued this matter in founding. We can't just go to a case and take a piece of it and then proffer that as a right to dicadendi. Let's look at why they quote this. They say, as regards the argument that the extradition request continues to have legal implications for Mr. Spachni's ongoing trial, it is essential for a proper consideration of that argument to quote the contents of Mr. Spachni's affidavit filed in support of his waiver of rights pertaining to the extradition. They are as follows, and then the quotes that you had, which was told to you is the SEA speaking, is the quote from that affidavit. In paragraph 20, the judge says, he made an unequivocal waiver of his extradition rights. Importantly, when he waived such rights, he stated that he fully understood his right to a hearing and that he and his counsel could challenge the extradition request. But before that, you will see the SCA already held in paragraph 17 and 18 that the appeal had no practical effect. And they just went on to consider this argument. This isn't a conflicting judgment as with regards to December or Mahala. It is not. What has been argued was said by the SCA was not said by the SCA. Well, in fact, said the appeal had no practical effect because Mr. Spachni was already back in the country, and they were just considering that further argument. Coincidentally, our learned colleague who appeared for the applicant when this matter was the first time argued. So, there is no conflicting judgment. Our colleagues have, as it happens, departed somewhat from the application, though the Lord would have realized it by now. But be that as it may, the second point is, it is said that there is a Muhammad test. And once more, what you've been referred to, my Lord, is the footnote and the academic scholars and what they say. Muhammad, the case itself, the heading of the passage where the court deals with this, at paragraph 61 of that judgment, says consent to deportation or extradition. Nowhere in this judgment, my Lord, will you find the Constitutional Court in Muhammad requiring consent or waiver to be in writing. I also find the submission that the Constitutional Court, the apex court, therefore this court must somehow arrive at the decision that it's not good law. My Lord, the submission is not only fundamentally flawed, it's wrong. We took care in the previous appearance to contextualize Muhammad. Muhammad does not contain any reservation whatsoever by the Constitutional Court, the apex court, with regards to a person's right to consent. The issue here was, and that is what the court said, where he consented to be taken, removed to a country where he faces the death penalty. That is doubted that he can do that. That he can surrender the inalienable right to life. That's what the Crown Court said. They didn't impose any requirements, as was submitted to you. The Muhala test the Muhammad test that has been argued at length now, you will not find in this judgment. I must admit, what I do not hear and what I do not understand from this argument's profit is why the applicant is said to have consented to an illegality. On what basis? She wanted to come home, she came home. Doesn't suit her, because when she came home, she was arrested at the airport. When did she consent to an illegality, to an unlawful? The moment there was no illegality. In the application for leave to appeal, one of the bases for the request that this court must grant leave was said to be that in Mahala in December, the appellate division did not consider the Constitution because they were given before the Constitution. But that's also not correct, Marlon. The appellate division, JA, specifically in Mahala at page 516, twice refers to the fundamental human rights. Whether there were infringements of those rights. Remember, the court has now been told that they're going to distinguish, the applicant's going to distinguish Mahala and December. But if you look at page 516 from paragraph F, then you'll see there were two accused. And with regards to accused number 2, relating to his voluntary acquiescence to travel to South Africa with the South African police from a roadside in Cisco to Sutherland, where he was arrested likewise, was not in conflict with his sovereignty, his fundamental human rights or South African law. The fact that he acquiesced meant that there was no violation of his human rights and there was no unlawful conduct. Ergo, Abraham didn't find application. The court was well aware of December. They were well aware of Mahala. I find it totally unacceptable for a party to come to this court and to say that when the Constitutional Court gives a judgment that they're not aware of the SCA and other cases. They are. It wasn't necessary for them to go here because there's nothing novel. There's no novel point here. There's no conflicting judgments here. This is an argument that the applicant wants to proffer. It's not supported by law. We're looking for a compelling reason, my Lord, because they do not have prospects of success. They do not have prospects of success because we don't read affidavits piecemeal. We read it in context. And there is no way that the applicant is going to convince any court. But where she, at the very least, acquiesced to come back to South Africa, that by doing so, she now waived or abandoned some constitutional right to be stuck in a country. She didn't want to be there. No court will make such a finding. So let us go to the second issue. The attack that the applicant launched here was always that she was abducted against her will in Tanzania by the South African police service. That was her case. That was refuted. She's moved away from you. My Lord wouldn't even hear anything about the applicant's papers today. So, when the Department of Home Affairs joined, the applicant persisted and proceeded with the attack against the South African police. She didn't amend a notice of motion. Fundamental principles, what are the affidavits in motion proceedings? The pleading and the evidence. You've been told why the case law we rely on is not applicable. But my Lord, if we read the passage that we've referred you to, in both these cases, then we join issue with the submission. In Minister of Cooperative Governance and Traditional Affairs versus the Beer, the SCA at paragraph 85, which we've quoted, says the following: what is more, even a superficial comparison reveals that the order which ultimately issued differed markedly from the compendious relief sought. Then goes on with regards to the declaration. In truth, respondents obtained very little by way of relief of what had initially been sought, and a great deal more than had actually been sought. The High Court ranged beyond what had been sought by the respondents. Thus, not only was the Minister denied a proper hearing, but the respondents were granted relief that had never been sought. In that sense, not only did the judgment suffer a failure of proper judicial reasoning, but it also failed to recognize and respect, as it was constitutionally obliged to do, the limits of judicial function and hence the separation of powers. So, when we go back to this point, my Lord, we go back to where we started the previous occasion. The first to third respondent was brought to court on a certain set of facts by an untruthful witness. She rejected her version, correctly so, because she said she was abducted and blindfolded, which she apparently abandoned. That is the context in which the first to third respondent answered. What is wrong with him saying to you, she says we abducted her, she voluntarily came back because she wanted to come back, because she told everybody she wants to come back. What is wrong with that? There's nothing wrong with that. The old adage that the law is an arse, but it's not such an arse. Cannot be more appropriate. Everybody that wanted to listen. Everybody that wanted to listen and hear. All and sundry.
Only the SAPS?
Sorry, Mark.
Only the SAPS?
The South African police says, she said it to everybody that was willing to listen. I want to go home to my children. That was her wish. Now, she says, contrary thereto, they should have left her there and followed a protocol, not bring her back. Because it doesn't suit her. The moment she consented or acquiesced, there is no unlawfulness, there is no illegality. Should they have left her in Tanzania when she wanted to come up? So what did the applicant need to do when it was decided that, oh, here's a new point I want to take? What's more simple than to amend the notice of motion? But they never amended the notice of motion. They, to today, have not sought anything against the Department of Home Affairs. They're still busy with the South African Police Services. And then they complain and say, my Lord, that this court erred because it should have granted an order that they never sought. This is what the Constitutional Court has said time. The rules pertaining to the necessity to clearly plead what you want. There's a difference if she came to the court and she asked for a declaration, but eventually another declaration could have been issued. But in this matter, she still seeks no relief against the DHI. So the criticism is unfounded. But once more, it's an attempt to get some footing to convince this court to grant leave to appeal. The problem is, Molly, but there is none. There's no conflicting decision. There's no Muhammad test. The law is more often than not about logic. We know what happened here. I said it the previous time, I say it again. She wanted to come home, she came home. The finding with regards to that, my Lord, is unassailable. The grounds proffered to you for compelling circumstances that warrant application for leave to appeal, we've shown you is fundamentally flawed. There is none. The concept of somebody acquiescing or consenting is not novel. There's nothing startling in it. And the court made a factual finding on the evidence. And an appeal court will be very loath to disturb such a finding, and in this matter, it won't be disturbed because the applicant didn't see fit to grapple with this issue. Not at all. An application for leave.
Referring to the blunt denial.
Yeah. Yeah. Because remember, my Lord, she was kidnapped. Done. There is simply no reasonable prospects of success on appeal. There's no compelling reason to grant appeal, and that is the end of this matter, my Lord. And if you dismiss the application for leave to appeal as we request you to do, we will request you to grant costs, including the cost of £2,000. May I just take a quick instruction? We've just made the point that Muhala decision, that's the one that was in 95. The interim constitution was well and alive when the Supreme Court of Appeal, of course, gave the Muhala judgment. The interim constitution. The point was made that the SCA, that these decisions are before the constitution, before the final constitution. The constitution was well and alive. But in any event, and you would see, my Lord, in both, in the Muhala decision, we've made a point of it, so I'm not going to repeat it. The court dealt with all the mainstay authorities that the applicant relied on for her argument in founding, when the matter was argued the first time. And as we've shown you, the SCA considered international law as well as the human rights of the accused. So it's again, it's wrong to say that the SCA didn't consider. They did consider the fundamental human rights when they gave those two decisions. And it makes sense, my Lord. I mean, it's logical. The applicant wanted to come home, she came home. It's as simple as that. We therefore pray that you will dismiss this application.
As the court pleases, my Lord, as my Lord has indicated, when we start, file a notice to abide by the court's decision, and we have done so, my Lord. I have, however, been instructed, as I have done, to file written submissions to my Lord as to what the position should be, and we adhere to that, my Lord. But may I just emphasize something, just two aspects, with the court's leave. My Lord, no court of appeals, no court will fault my Lord with the finding that Plascon evidence should have been applied, and my Lord correctly did so. In other words, the whole case had to be decided on the respondent's version. There is no doubt about it. My Lord, and then on that basis, Lord, if that is so, and my Lord found that there was consent, now, my little friend that it must be decided on the respondent's version, that is and is the end of this, my Lord. That is the basis of that finding. And if that finding is correct, my Lord, then there is no conflict between the decisions, and therefore they leave on that basis then should not be granted. But other than that, Lord, I abide by the heads of argument that we have filed. Is there anything else that Lord would like to hear?
No, thank you.
As a good please.
My Lord, I intend to be brief in reply. I wish to make one overarching point and then deal with a few smaller matters. The overarching point is this, my Lord. My learned friend for SAPS has made the case for leave to appeal with respect. He says he cannot understand what the illegality was. Well, my Lord, that's not up for debate. It's already been concluded. The extradition, we know they didn't in their written submissions in the principal case. All of the authorities are dead against them on it. Horseferry, Hartley, Dominowski, Casiriano, Burgos. International law turns its face firmly against the conduct of the respondents. I don't mean to re-argue the point, my Lord, but what is clear is that the protocol on extradition required the government, even if it wanted to act speedily, to seek a provisional arrest for Dr. Magudumana, submit an extradition request to Tanzania, and request the Tanzanian government that she be brought back quickly. It happens all the time. In fact, it happened in Spagni's case. The government could have done so, could have easily made an extradition request, telephoned through Interpol, made a request through Interpol saying, please arrest Dr. Magudumana, you'll have our formal extradition documents in the morning, have a speedy extradition inquiry and ensure that she's back. They did not do so. They chartered a plane, they acted in contravention of Horseferry, Hartley, and all of those cases that I mentioned. So whether my learned friend thinks that there isn't an illegality or not, perhaps he should argue that at the SCA. But what is clear is that in December and in Mahala, it was conclusively found that there was no illegality and consent followed. The opposite is true here with respect, my Lord. The court unequivocally found that they conducted their affairs unlawfully, but in any event found that consent was made. And that squarely raises the question postulated by Justice O'Regan: how can you consent to an illegality? The Constitution may well not recognize that. Not a word on Andrews from our learned friend. Not a word on Shaba from our learned friends. No attempt is made to show at all, my Lord, that Shaba is distinguishable from this case. So with respect on those 2 points alone, we submit that leave to appeal must be granted. May I deal with Spagni's case? Because it suggested that Spagni is entirely inapt. What happened in Spagni was this, my Lord. Spagni raised an international law constitutional argument about a powers question on who may submit an extradition request to a foreign state. Your Lordship doesn't have to concern himself with that. But by the time the matter went to the SCA, Mr. Spagni had already waived. So the question is this: what effect does the waiver have on Mr. Spagni's challenge? And the SCA said that it was moot, but the crucial reason for its mootness is because of the onus discharged by the state in that case, Ala Muhammad. And my learned friend is correct, I was in the case. That was the debate. What happened there was the NPA produced an affidavit, and that affidavit attempted to discharge the Muhammad onus to prove that there was unequivocal consent. And that's why if your Lordship turns to Spagni, your Lordship will see as part of the order that was made is that leave to adduce the further evidence on appeal was granted. And it was precisely granted, my Lord, because the state intended in that case to discharge an onus, which it did. Your Lordship will find that at page 31 of the authorities bundle, paragraph 26, leave to adduce further evidence is granted with no orders to cost. The state in that case went through the Spagni's affidavit. They demonstrated rule of speciality, double criminality, prima facie case. all of those requirements were satisfied. So with respect, the distinction that my learned friend tries to make in relation to Spagni is entirely inappropriate. There was no meaningful engagement, we respectfully submit, on the Modderklip line of authorities. No attempt is made to demonstrate why De Beer still applies in light of Modderklip. And what we of course know is that De Beer just had absolute, with respect, my Lord, was not at all concerned with the question in Modderklip, which is, if you find that there's an unconstitutionality, you must make the order. The court said the opposite in De Beer. It said the High Court didn't properly apply a constitutional analysis to rationality, so how could there be a finding of unconstitutionality? It didn't exist. It dismissed the application. Precisely for that reason, rationality failed. So, in conclusion, my Lord, because you've heard nothing with respect on Shaba, we say that alone warrants leave to appeal to the SCA. We know from Noble Properties there's no more compelling reason than a conflicting judgment to grant leave to appeal. We say that our learned friends have made out a case for leave to appeal in their non-understanding of the illegality. We say, with respect, that Hartley, Horseferry are on all fours, and if they wish to argue that there wasn't an illegality, that opportunity should be seized at the SCA. Those are the submissions for the applicant in reply. Thanks, the court, please.
Gentlemen, thank you for your submissions. This court will pay due consideration to all the submissions that was provided to the court today. And its decision in this application on the second court day from now, that is Tuesday, the 18th of July 2023 at 9:30 in the morning in this courtroom. I understand that counsel will probably be busy with other business, so counsel are excused from attending the proceedings on Tuesday, the 18th, as long as attorneys for the parties are present in court. That will suffice. I might just add that the decision that I make will also be handed down in written form on Tuesday. Thank you. Court will now adjourn.
Kamogelo Sikwe. Kamogelo, good morning. Thank you once again for making time for us. So what did we hear in this application?
Well, Aldrin, we heard from Dr. Nandipha Magudumana's legal representatives this morning, of course, expressing what is contained in their heads of argument that the process to bring back Dr. Nandipha Magudumana back to the country was actually unlawful and it was illegal. They are saying that they told Judge Loksha that it is in the interest of justice to have, to grant rather Dr. Magudumana her leave to appeal and to take the matter to the SCA. They did say to the judge that the process was illegal, and that is the reason why they want the SCA to test the legality of that process that brought back Dr. Nandipha Magudumana back into the country. We also heard from the Department of Home Affairs as well as the South African Police Service, who are of course opposing this application to grant Dr. Nandipha Magudumana leave to appeal. But I have with me her legal representative, Machini Mutloung, who I would like to bring into the conversation, just unpack for us what is it that you actually want the SCA to look at, where should this matter be, this appeal be granted?
Issues that you are raising are quite succinct. That one, the court found that the extradition, which, by the way, SAPS and DHA have always been, insistent that it is lawful. But the court has found that extradition, actually it was a deportation according to them, but the court found that it was a disguised extradition. Now the only point which the applicant seeks ventilation and proper ventilation at the SCA is whether the court was correct in sort of saying she consented to the deportation or to an illegality, because we are saying that if the court found the extradition to be disguised, that is an unlawful act, that is illegality. The argument that we are presenting here is, can anyone consent to an illegality? But of importance as well is, can this be seen to be consent within the parameters of the law? Was this consent informed? And in this instance, I think our counsel eloquently outlined the requirements that has to be fully satisfied for a consent to be deemed to be informed.
We heard from counsel from South African Police Service saying that, insisting rather, that consent was given and the buck stops there essentially. What are your impressions about that?
Look, even to this date, bizarrely, this consent is given to all and sundry. Is it not tantamount to giving consent to whom it may concern? We still don't know who this all and sundry is or are. It would seem that the applicant was on a loud hailer, just telling everyone that I want to go home. That is precisely a crisp legal question, which we are of the view that the Supreme Court of Appeal will be in a position to respond to, and the Supreme Court of Appeal may reason differently around this question.
The judgment is reserved until Tuesday. What are your expectations?
And look, we launched an application for leave to appeal. We still of the view that leave must be granted so that the SCA should really ventilate on a whole range of legal questions emanating from our application for leave to appeal. In our view, we would really want this matter to be heard at the SCA until the 18th of July. By the way, that will be Matiba Day. So let's see. We remain hopeful, and we remain optimistic that the outcome will be in our favor.
Let me take you a little bit back to yesterday. Your client received a visit from the Commissioner of Correctional Services. Firstly, did you know about that, and what are your impressions?
Look, we didn't know about that. We're quite dismayed, particularly having had the reasons for such visits. Of course, one heard that this was more of a routine visit, but when one looked deeper into it, it was triggered by some, media reports on favoritism and other, treatments and conditions upon which our client is seen to be, staying. And our view is these issues ought to have been canvassed with the legal team so that we are fully aware of the visit, we are fully aware of the reasons why the commissioner had to go there. We will be consulting with our client this afternoon, and we'll get more information and instructions on exactly what transpired during that visit. But for the department to react to each and every allegations in the social media, and some of these allegations are sporadic in nature, I believe that proper investigations on such allegations need to be done first, and with proper notification to the legal team. And this was not done, and we are quite dismayed regarding such conduct of the department.
Thank you so much, Mr. Muklong. That was Machini Muklong there, just summarizing for us their arguments that they presented in court today regarding their application for leave to appeal in the matter involving Dr. Nandipha Magudumana. Dr. Nandipha Magudumana, of course, brought an application to the court to get her arrest in Tanzania declared unlawful. Judge Philip Lobsher did find that the process followed to bring her back here was unprocedural, but on the basis that she consented, he then dismissed that appeal. And today we were here to hear another application to challenge the verdict that Judge Philip Lobsher issued in this court. He did postpone the matter to Tuesday, when he will be granting his judgment in the matter. It's back to you in studio.
Thank you so much, Kamogelo Sikwe there. Let's move over to